As Starbucks employees across the country continue to try to unionize, the company has appealed some of their employees' efforts all the way to the Supreme Court. Back in 2022, a group of 7 Starbucks baristas at a store in Memphis were fired after attempting to unionize. The National Labor Relations Board, or NLRB, concluded that Starbucks unlawfully fired them. Then the agency sought an injunction to get the company to rehire those employees. A U.S. District Court judge granted it, and the 6th U.S. Circuit Court of Appeals upheld the decision. But Starbucks has said the workers were fired for violating company policy and appealed the case to the Supreme Court.
So Starbucks is asking the Supreme Court to essentially force the NLRB, the National Labor Relations Board, to follow the same criteria to obtain a preliminary injunction that every other federal agency has to follow.
The constitutional question before the High Court is whether courts must evaluate the NLRB's request for injunctions under a traditional test or a more lenient standard. Mark Chenoweth filed an amicus brief for the new Civil Liberties Alliance in the case, supporting Starbucks, and says there is an equity issue at play with the NLRB.
It's very easy for them to get a preliminary injunction, or certainly far easier than it is for any other federal agency. And that just really has an effect on making the playing field unlevel.
But Smita Ghosh with the Constitutional Accountability Center says the standard that Starbucks is pushing for ignores a lot of the history of federal labor law. In the brief she filed, she says back in the 1930s and 40s, when Congress was writing and revising labor law, they wanted to limit the court's role and didn't want federal judges to look into strikes and issue injunctions to prevent labor unrest.
It ended up being a practice that really aggravated violence and kind of disputes between labor and management. So Congress chose another way, which was this federal agency, which is why the government standard, which kind of involves a little bit of deference to that agency, is appropriate.
In Washington, I'm Stetson Miller.